Honorable Speaker, it appears as if there was a machination to look out the different stakeholders. And yet you committed, Right Honorable Speaker, that there's going to be adequate time. And I said, we are going to follow your guidance, which you gave here. But that did not happen. I don't want to think that the Speaker lied to us as the House. Or could it be that the committee disregarded your ruling? Because when you speak, when you're in that chair, you're giving guidance and ruling. You said...
On Tuesday, Uganda Parliament passed the Uganda People's Defence Forces Amendment Bill 2025. This is intended to see civilians tried in the martial courts. The bill was introduced to have reforms in the military justice system, restructures health service for armed forces personnel, and streamline veterans affairs. This bill also establishes a directorate of military prosecution to professionalize the process. It also protects against premature execution of a death sentence until it is confirmed by the Supreme Court. Additionally, the bill sets out clear apparent process for courts martial decisions, from unit court martials to the division court martial, from division court martial to the general court martial, from general court martial to the Court of Appeal, and finally to the Supreme Court. Presenting the motion on Tuesday, 20th May 2025, in a plenary session chaired by Speaker Anita Among, the Minister of Defence Force and Veteran Affairs, that is Honorable Jacob Oboth, said the bill is not about subjecting civilian to military courts arbitrarily, but targets those who engage in military-related offenses. So this law, he said, addresses civilians who acquire arms or equipment used for violence, those who masquerade as militants, and those who commit offenses in collaboration with the military personnel. He said there should not be fear that this law targets all Ugandans.
Sugar levels are a bit, I beg your pardon. Right, Honorable Chair. It's a common practice that if a proposal like the one that is my good friend Jonathan, Honorable Jonathan Oduri is making, yes, we can make you give us the powers to make the regulations, and we also lay before this Parliament for information and, yeah.
Address yourself to Section 52 of the 252 of the Parent Act.
Tabling the report of the Joint Committee, Honorable Wilson Kajwenje, Chairperson of the Committee on Defence and Internal Affairs, said the committee examined this matter and concluded that the trial of civilians by military court should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The bill responds to the Supreme Court's decision in Attorney General's versus Honorable Kabaziguruka, Constitutional Appeal number 2 of 2021, which found that the trial of civilians in military court under the current UPDF Act was unconstitutional. So Kajwegi noted that the proposed changes required structuring of military court to ensure independence and transparency. He said this requires changes to the military structure to ensure that those presiding over trials are appointed through a transparent process and operate independently of superior influence. The bill introduces reforms relating to the structure, appointments, and jurisdiction of military courts. However, the committee also raised several concerns. 1. The role and mandate of the military courts department are vague, leaving gaps in oversight and accountability. This overlap of judicial and prosecutorial role is a violation of a natural justice. On judicial appointments, the committee recommended that there should be increased civilian oversight and the administration of judicial oath, a proposal upheld by the House. The committee contended that military courts must be governed by the judicial oath and legal standards. Military court judges should be appointed by the Commander-in-Chief on the recommendation of the Judicial Service Commission from a list generated by the High Command. The committee further proposed that appeals from the General Court Martial should lie with the Court of Appeal. Regarding military property, the committee recommended the regulation of military-style attire that lacks UPDF insignia to distinguish it from civilian wear.
Whether it is constitutional for civilians to be tried by the courts-martial as principal for offences under sections 1191H of the UPDF Act. Yet all those also exist in the civilian offences. Right Honourable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or a mere tribunal. In answering this question, Right Honourable Speaker, which answer was agreeable to the rest of the panel, Honourable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows. I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. One is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A. Members of the General Court-Martial must be persons with requisite legal qualifications. B. The members of the General Court-Martial should be independent of the command and have security of tenure. C. There should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D. The convening authority must lie with the General Court-Martial, which guarantees institutional independence from the authority prosecuting the case.
Despite a walkout by several members of the opposition, led by Honorable Joel Senyon, that is the leader of opposition, the handful that remained in the chamber poured up a spirited fight. That is, Minority Report authored by Honorable Moses Okot, MP from Kyoga County, criticized the bill as unconstitutional and contrary to the Supreme Court's judgment. Honorable Kajweji and Honorable Okot presented the majority and the minority report respectively. So, Clause 30 proposes the introduction of a new section, that is 117A in the UPDF Act, which provides for other persons subject to military law. This is a reenactment of Section 117, which was struck down by the Supreme Court, or court argued in the House. He described the move as a serious affront to the rule of law and an attack on judicial independence. Okoth also condemned efforts to reintroduce previous nullified provisions such as an action amount to contempt of court, which is criminal. Quoting the Supreme Court ruling, what Clause 30 presents is a reincarnation of a provision already struck down by the Supreme Court. This is not the conduct of civilized nations, he said. He further warned against granting military courts power over civilians. The minority report notes that, including offenses such as murder, aggravated robbery, kidnapping with intent to murder, and treason as service offenses, effectively extends military court jurisdiction to a non-disciplinary crimes. This contravenes Article 209 and Article 210 of the Constitution. He maintained that military courts are internal disciplinary bodies, not substitutes for ordinary criminal courts. Honorable Jonathan Odul, UPC Eruti County MP, who also dissented, warned that the passing of the bill will be remembered as a birth of military dictatorship. He said, if Parliament passes this bill, the day will be remembered as the birth of military dictatorship. This bill is a direct assault on the Constitution and the rule of law. The Supreme Court was clear. Civilians must not face military tribunals, he urged. He also maintained when he said, imagine a future where any civilian, opposition leader, activist, or journalist can be dragged before a court-martial. This is not the Uganda envisioned in our constitution. Honorable Fox Odoi Onyoreo in Alim West Budama, Northeast County successfully moved a motion to suspend Rule 214 Clause 14, allowing debate on the matter to proceed.
It's unfair for the Honorable Dur to reopen a debate that he lost at the committee level.
Thank you.
Only propose a slight amendment of surviving members of the High Command on the as of the 26th, because as we talk now, the list includes people who are deceased.
During the debate, Honorable Gilbert Olanya, FDC Clerk South MP, demanded clarity from the Attorney General on what constitutes exceptional circumstances under which civilians can be tried by the military court. The Minister of State for Sports, Honorable Peter Ogwang, criticized the narrow focus of the debate on civilian trials, urging that the bill broadly enhances the welfare of the armed forces. He said The court-martial has enabled our people to return home and to their farms. Where were you when our cattle were stolen by rustlers? To say the court-martial has failed in Karamoja is unrealistic.
I want to stand here and confirm that I'm here to support the majority report which has been presented by the Chair of Defense and Internal Affairs. Number two, Madam Speaker, with your permission, allow me to say the following, colleagues.
Continue.
Madam Speaker, I need to be protected by Honorable Nsereko so that I can make my case.
Honorable Nsereko, why don't you leave your colleague, then you come. Honorable Guan, continue.
Madam Speaker, first of all, I want to address myself to the country on a matter which are regarding the Uganda People's Defense Forces Amendment Bill. I hope the country clearly understands what this amendment is all about. Why am I bringing this? We seem to be only tailoring the bigger picture of the bill to one item which is now discussing about the court-martial. And I want really fellow countrymen and women to first understand the objective of this bill helps us to improve the welfare of our defense forces, which at all times lives to protect this country where we all cherish, whether we are in parliament or not in parliament. However, allow me to address one issue on the minority report. Madam Speaker, and I want to read it verbatim, and it pains, and specifically from my brother, Honorable Jonathan. Madam Speaker, give me 1 minute. The scenario of Karamoja, which I want to quote from his minority view. The scenario of Karamoja, which was presented in the committee as a success story of court-martial, was unjustified. It was claimed that the judicial officers had feared to be deployed in Karamoja as a hear case because of insecurity. And he asked the following questions. My brother, I'm a victim. I am a victim here. If we talk about Karamoja, I am a victim. If you talk about Karamoja, my mother was raped. If you talk about Karamoja, I lost my father. If you talk about Karamoja, I'm still losing people up to now. What are you talking about? When we are here, friends, let's be sincere to ourselves. Some of our people are not sleeping in their houses because of Karachunas who continue to make our people suffer. Friends, this law, this court-martial has helped our people to begin going back to their homes. Friends, our people are now able to go back to their gardens to work because of the court-martial. Where were you at that time when there was no court-martial? Were we not in camps? So when we are here, friends, Honorable Jonathan Odu, our cows left. Where are our cows? Is it Museveni who took our cows or the cattle rustlers? Is it indeed Museveni who helped us now to begin even going to compensate on our cows, which were taken by the cattle rustlers? So friends, when we are here, Madam Speaker, for you to come and insinuate that the court-martial case is not a success in Karamoja is entirely being unrealistic, being not nationalistic, being...
Honorable Patrick Nsiaji NRM Kachumbala County said civilians who take up arms or handle military hardware should face the court-martial. The Kampala Central Division MP Honorable Muhammad Nsereko opposed the clause allowing civilians to be tried in courts, in military courts, and called for its deletion, albeit unsuccessful.
The Penal Code Act is very clear. Are we setting two standards? When asked, you clearly said we are not setting two standards. It clearly states any person with malice aforethought takes the life of another, commits an offense, and is liable to the punishment as prescribed under the law in the Penal Code Act, or commits the offense of murder. Now, the question people would like to be alive to, what is exceptional in the description of that offense? Because an offense that is not well prescribed.
Despite strong objection from the minority, the Parliament passed the bill with amendments.
You talk about it being exceptional. Can you redefine murder with exceptions? Because the ingredients must be clear, and the Land Attorney General knows exactly what I'm talking about.